This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
I will introduce our speakers for today. So up first is Judge Susan Lopez Giss. Following a remarkable legal career, Judge Lopez Giss was appointed to the bench in 2007 and served 15 years as a judge, with the entirety of her time on the bench devoted to family law. Judge Lopez Giss presided over thousands of cases involving all types of contested and complex family matters, including parentage changes cases, custody and visitation issues, child and spousal support, business valuation, and property division. In addition to issuing thousands of rulings, Judge Lopez Giss became known for actively and successfully settling her cases. Her strong legal mind, coupled with an emphasis on collaboration to resolve family disputes, has resulted in her reputation as an effective negotiator, problem solver, and educator. Judge Lopez Giss previously served 30 years in the Los Angeles City's Attorney's Office, where she helped develop a groundbreaking domestic violence diversion and counseling program that was implemented statewide. Thank you for being with us, Judge Lopez Giss.
Thank you.
Next, we have Michael Hanasab. Michael B. Hanasab is a partner at Jamra Hanasab LLP in Beverly Hills, specializing in family law. He handles high asset divorce, child custody, support matters, prenuptial agreements, property division, and domestic violence cases across California. Admitted to practice since 2006, he earned his law degree from Loyola Law University, Los Angeles, and a law and society degree from UC Santa Barbara. Skilled in both litigation and alternative dispute resolution, he serves as a family law neutral for the Los Angeles Superior Court. A former entertainment industry professional, he brings unique insight to his legal practice. He is an active member of the Beverly Hills Bar Association, Los Angeles County Bar Association, and the State Bar, and regularly contributes to the California Family Law Report. Thank you for being with us, Michael.
Thank you.
And last but not least, we have Judge Lawrence Riff. He is a supervising judge in the Family Law Division of the Los Angeles Superior Court. Judge Riff was appointed to the Los Angeles Superior Court in 2015. His assignments have included criminal misdemeanors, civil trials, and family law home court and long cause trial departments. Before judicial service, Judge Riff was a partner of the international law firm Steptoe and Johnson LLP, where he served as the firm's managing partner for Los Angeles for 17 years, and a practice group leader for the firm's U.S. Toxic Tort and Environmental Litigation Practice Group. Thank you for being with us, Judge Riff.
Well, thank you. You know what? I need to update my resume because I am no longer the supervising judge of the civil division. Judge Shelley Kaufman is.
Well, there you go.
I am now the supervising judge of the civil division. So I'm sorry.
Amazing.
I'm sorry if I sent you the wrong bio.
No worries, no worries. All right, well, with that, I will go ahead and share my screen, and I will hand it over to Judge Lopez Giss.
Thank you. So, slide 3, please. First of all, I want to welcome everyone on this Zoom MCLE session. Today, Judge Riff and Mr. Hanasab and I are doing the second, it seems, in the series of discussing the domestic violence cases with respect to initially evidence and today recording evidence. But because we have dealt so deeply and talking so much and different opinions, for the purposes of this session, I will be Susan because that is who I am. And Mr. Hanasab will be Michael, because that is who he was named, and Riff is Riff. So just so that you know, we don't mean any disrespect, but for the purposes of this presentation, we want to be informal because the presentation itself is pretty formal. For those of you who have tuned in, Penal Code Section 633.6 has a provision in B that has seemingly become a seismic phenomenon within the family law world. 633.6a is something that's been in existence since the restraining order statute was enacted, meaning that when a victim would get a restraining order and seek to have the offender or the oppressor forbidden from contacting that person, the best way seemingly to make sure that didn't happen or a record of it occurred was that the court would allow the victim to record any conversations, be it in person, be it on the phone, or in the presence or of other people where there could be a recording. And that way it would provide a disincentive for the abuser to continue the offensive conduct. That section was enacted because, as many of you already know, it is against the law to record someone without their permission in the state of California, within various exceptions. And 633.6a provided that exception. But recently, within the last few years, there has been an amendment to 633.6, which allows B. And in that situation, the legislature recognized that when an individual wants to establish that there's been a course of conduct that's abusive in nature with respect to threats or oppression, it was the quintessential he said, she said in those situations, and recordings would be theoretically the best evidence. And so 633.6b allows a person who reasonably believes they're a victim of domestic violence to record conversations, and these confidential conversations being recorded could then be utilized in court. The question that's going to be discussed in many different connotations this morning or this afternoon is that how far back can these recordings be made? And also, what is and isn't domestic violence that can be, in fact, recorded? With the enactment of this section, there are so many more questions that have been posed in court, both from the court's perspective, but also the defensive perspective of the person who's responding to the restraining order allegations. Hopefully today we can provide answers, but I will tell you when this session is over, there may be even more questions because as the Court of Appeals has ruled, there are more questions seemingly that will be addressed. So with that, I believe it is next you, Michael.
So if we go to the next slide, there we go. The big question when looking at this, at the penal code section is, does a domestic violence restraining order need to be filed before Penal Code 633.6 applies? Because that questions of who is the victim of domestic violence. The answer is no, based upon the BRC case, which is cited in this slide. And in the BRC case, there were 3 recordings that were admitted, which recordings were recorded prior to the victim filing a domestic violence restraining order. And a question was raised as to the admissibility of these recordings. And the court found in the BRC case that the recordings were an exception to Family Code 2022 by way of Penal Code 633.6. And in finding this, the BRC court looked at the language of 633.6, specifically subsection B, and hung its hat on the word seeking. And the fact that the court said 633.6b references a party who is seeking a restraining order. And the court found in the BRC case that the word seeking does not require a party to have filed a domestic violence restraining order prior to the exception of 633.6 applying. And in doing so, the court looked at the policy of 633.6 and said, so long as the victim intends to file a restraining order and reasonably believes that the communication may contain evidence germane to that request, regardless of whether a restraining order request has been filed with the court, the exception applies. And that was at page 266 of the BRC case. And the court stated that it helps the court with a he said, she said situation and aids the victims in submitting evidence of a domestic violence restraining order without the fear of retribution of violating the penal code. And it also aids, and I think this is a big one, in making a credibility determination in the he said, she said situation, because how many times in a domestic violence restraining order do we have party A saying, I said this, party B saying, no, I didn't. And then the court has to look at a he said, she said. Now, when you have a recording, that kind of eliminates that he said, she said. But it does open up a question of how far back can we go on these recordings for 633.6 to apply? And then in the BRC case, there is also a question of what a lawyer should or should not do with these recordings, because in the BRC case at the trial level, there was motions in limine filed. But when the recordings were played, the court asked counsel if they had any objections to the admission of the recording, and counsel said no. So that's a practice pointer to keep in mind as we move forward. Judge Riff, what do you think?
Well, I think a lot of things. And let me say this, whatever I think, I'm not speaking on behalf of the Family Law Division of our court. I'm not even in the Family Law Division of our court anymore. And I'm certainly not speaking for the LA Superior Court. Anything I have to say today is me and me alone. And my lawyer tells me I should say that I am not commenting on any pending case, because I'm not. All right, so would you mind, we're going to go a little bit, we're going to call an audible here. Can you go back a slide, Anna? Yeah, let's just take a look at 633.6B again. I want to emphasize just a couple of things that both Susan and Michael have said. So the big picture, bear in mind, is essentially a right to privacy that is found in the California Constitution, Article 1, Section 1, if I'm not mistaken. The criminal law has criminalized certain invasions of privacy. And then there are exceptions to the criminal liability that flows from there are exceptions to the act that would otherwise be criminal. Now let's look at B. B is an exception. So notwithstanding, meaning despite, the provisions of this chapter, and with a tip to the hat to federal law that requires this, a victim of domestic violence, okay, that's number one, a victim of domestic violence who is seeking a domestic violence restraining order from a court, that's item 2, and who reasonably believes that a confidential communication made to him or her by the perpetrator may contain evidence germane to that restraining order, may record that communication. For what? For the exclusive purpose and use of providing that evidence to the court. Now, there are so many questions embedded just in that. For example, is one immunized from the penal code if one is found not to be a victim of domestic violence, even if everything else, even if all those other conditions are met? Interesting question. The last clause of that section, for the exclusive purpose and use of providing that evidence to the court. In what? In the DV action or in something else? So when Susan says that when this hour is over, you're going to have the answers to many things, I'm not so sure. I'm with her that you may have more questions than we have answers. All right, so with that, let us go forward 2 slides. And this is the question Michael put to me, basically. Well, how far back can you go to record? So the BRC case tells us, well, you have to be seeking a restraining order, but seeking doesn't mean that you have already filed one. And Michael said these words. He said, you have to have the intent to seek a restraining order. Isn't that what you said, Michael?
Yes, I did.
Okay. So the answer to this question, in my view, for which there's no case authority, by the way, is that so long as the person who in good faith believes that he or she is a victim of domestic violence and has the intent, the present intent to seek a restraining order, may record a confidential communication if that person reasonably believes that that may provide evidence germane to that DV proceeding. So
Riff.
that's how far back you can go. Yeah.
Well, I want to underscore this particular conversation with the following scenarios, both on the bench and in my current iteration of myself. I've seen these recordings come in, or excuse me, be attempted to be presented or discussed, and they go back several years. And no filing of restraining order occurred within those several years. And when questioned in court or in private, I ask, how long have you been recording? Well, we've been having fights, and I just felt that they would be evidence sometime in the future to protect me, to show that there's a history of what has gone on. Now, those words in my mind are not specific enough intent. It's basically an insurance policy so that if anything ever happens, then I can use them. If I go back and weed out the ones that are a year or two ago, and then within the last 4 or 5 months, and maybe there are 4 or 5, and then the restraining order was filed, does that make it an intent to seek a restraining order? Or does it get weighed down by the fact that they were insurance policy for some potential time in the future where they could be of value? I have seen this on more than one occasion, and I don't think that the people who are recording know anything about 633.B. And to me, it's problematic, but that doesn't stop the attorneys under 633.6 to argue that these should come in. I just like to have your thoughts, Michael, as counsel, and Riff, your thoughts as to this situation, because I've seen it so often that this is more often the practice than somebody who is specifically aware that sometime in the future they need to have this evidence.
So at least from my side, and I think this kind of goes to the point that we're emphasizing, is that you're going to end today with more questions than answers. The BRC case did indicate that there were recordings that were approximately 3 weeks prior to the filing of the restraining order, and said the short time in between the filing and the recordings played a role in the court's mind to admit it. But the court also indicated that the victim testified that the recordings were made for the protection of herself and the minor children, and that testimony helped fit under 633.6. So I don't think BRC clarifies it. There's another case which we've discussed. It's the Malinowski case, MALINOWSKI. It's a 2024 case. And for those who want the site, it's 104 Calap 5559. That case dealt more with, didn't really get into the penal code section, but did address it in dicta, in the idea that mom was recording custodial supervised custody exchanges from a camera in the car. And the court ultimately said, look, monitored custody exchanges are not confidential, therefore the penal code doesn't apply because it's not a confidential communication. You should know that the whole idea of a monitored visit is that it's monitored, so you lack the confidentiality. but the court did indicate in that case that mom was recording these interactions for a significant period of time. I think it was approximately a year prior, without any intent to file or to seek to file a further restraining order. Therefore, it might not apply. So there's more questions than not. And from a lawyer's perspective, I think you have to make a determination of, what is enough time. And if you're filing a domestic violence restraining order, remember, you just have to show by the preponderance of evidence of one past act of abuse. So how far do you open your client up to potential liability by presenting recordings 2 years back? Is that too far? Do you even need that? And then if you do need that, do you bring it in under 633.6, or are there other ways to bring it in, with testimony, and you potentially use it as impeachment? Judge Riff? Or Judge Giss? Sorry, I don't.
No, Riff, you go ahead.
All right, I will. So Michael, let me ask you a question. Let's say, hypothetically, you're in a closed counseling session with your client, and the client says, look, I have these recordings from X number of weeks ago. And you say, well, at the time you recorded it, were you intending to seek a restraining order? And the client says, well, I was thinking maybe I would. All right. And that's the state of the record. You now know that. If asked in open court under oath, presumably the witness will tell the truth and say that. Would you seek to admit those recordings on that record? Is that close enough to BRC for you to take the risk or not?
Before he answers, can I answer for him?
Sure.
And then I want Michael for you to tell me if I'm wrong. I posed this scenario about tapes going back a period of time. And I also indicated that I seriously doubt that anyone who's recording knows anything about 633.6, A or B. And when an individual says, I'm using them for protection, I think that in my mind is enough. And the reason I'm saying that is enough is that protection from what? I would submit that they're saying protection to show that at a point in time that they've been a victim. And I think that's enough in my mind, of a kernel of fear to think that I might need these in the future. And how they'd be used in the future, I don't think we can expect, nor do I think the Court of Appeal expected any victim to be savvy enough to know, oh, yes, well, under 633.6B, I better start keeping these and, inventorying them because I'm going to be seeking a restraining order in the future. I think it might be enough. That's my argument. I don't know if another one of my colleagues on the bench would agree, but I think that client telling you this is basically telling you that they felt they needed something else rather than their words. Michael?
I agree. I think it's very hard to expect that a client is going to use the exact words of the statute. They don't know about it. We live in a new world order where everyone has one of these in their pocket, which is a recording device, essentially. And it allows us to get evidence that, I mean, when I first started practicing family law, we would never dream of. And now you do have it. If I'm on the other end of it, however, and that's the testimony that comes up, I would definitely object to it, to at least try to get it out. I definitely probably would even file a motion in limine before the hearing to try to exclude it at the very least, because look, it's not going to help you if the recording comes in, assumably. If you're going to if you want to present it, I'm assuming that recording is going to be damning.
Well, okay. So I have a couple of rejoinders here. But Michael, I'm not sure you actually answered my question. So, your client is telling you, in essence, well, I didn't have the present intent to seek a restraining order, but I thought I might. And I'm asking you, under BRC, do you think that that is close enough that you're willing to take the risk of offering them? And if you're wrong, potentially subjecting your client to a criminal prosecution?
I don't think, I think under BRC, the language was that the victim testified the recordings were made for the protection of herself and the minor children. It was never, I was planning to seek a restraining order. It was, the testimony was, I made the recordings for the protection of myself and the children. And the court said, it was a few weeks before you filed, so we could assume the intent was that you were going to be seeking or the potential to be seeking. So yeah, I would feel safe enough using the BRC case to say, look, this kind of falls under the umbrella of BRC.
I only have two other comments then in rejoinder. First of all, I don't think I disagree with you, by the way, but our legislature is not incapable of expressing itself as to what it means when it comes to domestic violence kinds of legislation. And when it said is seeking, it certainly could have said or may be seeking or it possibly intends in the future to seek, and it didn't do that. And our legislature, one might say, is not exactly hostile to offering protections to potential victims of domestic violence. So there is a statutory construction point there. Here's the other thing I would point out to counsel. The further back the recordings are in time from the date when somebody actually is seeking the DVRO, the more tension exists, because remember, in seeking the DVRO, one is seeking equitable relief from the court. More than that, seeking a temporary restraining order, which speaks to imminence of urgent harm, such that the court needs to act immediately and possibly even impose pretty strict strictures, I'll put it, on the on the respondent who has no notice. You're out of the house, you're not going to see your kids for at least 3 weeks. So if one is thinking, well, someday maybe I might seek a restraining order, and for that reason I was doing all that recording, that runs right up against the notion that, well, you need immediate temporary restraining order relief today. So I would just bear that in mind.
I'd like to focus in on that point. As a former prosecutor, as the person who I think I have to fix my resume too, because it wasn't the domestic violence diversion program, which there was that I did draft. It was the domestic violence prosecution program. On slide 4, there was the heading, who is a victim of domestic violence? And I can tell you, as a person who filed thousands of these cases, the question of who is a victim becomes pretty murky when somebody has been recording for several years or for 6 months or 8 months and doesn't do anything about seeking help. And there's the libraries are filled with books, both in person and virtual, of the explanation that victims are afraid and don't go forward. But the dilemma with some of these tapes is that in the desire to prove that it is not he said, she said, there's a fine line in many cases between coercive control and verbal abuse and people just arguing. And where is that line? And oftentimes these tapes are taken out of context, which we'll get to in some of these later slides. But the dilemma of age brings some real credibility questions into play. And I just would caution any of the and all of the people who are listening to this today, that you may get a court to listen to these tapes, but it may actually open up a whole new set of problems with time, credibility, and the ultimate question, was this a victim? And I don't know. Each tape is, and each case is specific, but I think it's important for everyone, at least the three of us, but also the people listening, to recognize that question. The statute specifically states who is a victim of domestic violence. And if someone is recording and not doing anything with it and thinks that they may use it in the future, and then you listen to these tapes, it may end up backfiring.
We better move forward.
Okay, move forward. I think that's me, right?
Yes.
Okay, page 6 is a hypothetical. So mom has a front door that has a recording. I don't know whether it's a specific Ring camera with a recording device or a nanny cam, but dad is telling their son, don't let mom know I let you smoke marijuana at my house. And mom has been recording this. Mom's recording. And dad doesn't know. Nobody knows, because mom records everybody who comes to her front door, or specifically in this case, dad. Is this a confidential conversation? And is it admissible? Michael?
So I think, one, there's a difference of whether or not it's a Ring camera, or there's a potential difference of whether or not it's a Ring camera or a nanny cam that's like hidden. If it's a Ring camera and it's, we're in 2025 now, most people know, a Ring camera is recording. And then it questions whether or not you have a reasonable belief that the conversation had at the front door looking at a Ring camera is confidential. And it kind of goes into the Malinowski case that we talked about previously, in that, is that a reasonable belief to have a confidential communication when you see a Ring camera? On the other hand, if it's a nanny camera or hidden camera or a recording device, let's say in the planter, that you can't see, to me, that would be a confidential communication, in that you're looking, you look around, you see no recording device, you're talking at a front door. I think that would fall under a confidential communication. And then you need to find an exception to bring that in if you're going to try to bring it in.
So 632 of the Penal Code, subsection C, defines what a confidential communication is. And it means a communication carried on in circumstances as may reasonably indicate that any party to the communication desires it to be confined to the parties thereto, but excludes a communication made in a public gathering, etc. And then there's kind of a residuary clause at the end, or in any other circumstance in which the parties to the communication may reasonably expect that the communication may be overheard or recorded. I think that's what you're hanging your hat on, Michael, there at the end, which is, in 2025, if you see a Ring camera, one cannot reasonably expect that the communication will not be overheard. But otherwise, dad just talking to 14-year-old son strikes me as a communication one would reasonably believe is confined to the parties there too.
The hypothetical says mom has surreptitiously set up a recording device. So I think my utilization of the phrase Ring camera was probably misstated. Not all Ring cameras are recording conversations, but nevertheless, in this specific scenario, it is surreptitious. But here's the question. Even if it is surreptitious, even it is confidential, what dad is basically saying is that I don't care that you are basically breaking the law because 14-year-olds cannot smoke marijuana, and it's under the guise of child abuse or child endangering. So it is a basis to get a restraining order against someone when they're putting their child at risk. So I would think that the restraining order statute in BRC is triggered here, at least hypothetically, and I think at least initially, because even assuming it's a confidential communication, it's a communication that is somewhat evidential in my mind, probably more so, of potential child abuse or endangering. What do you think about that?
Well, I think what's interesting is this isn't in the hypo, but let's add a fact, which is until mom heard that statement, she had absolutely no intent of seeking a restraining order. It never dawned on her that she might need one. So if that's the case, then the is seeking or may be seeking in the future conditions of BRC really aren't met. I mean, it's evidence that now that I have it, I'm going to be seeking a restraining order, but it's, if it is a confidential communication, it's being recorded is unlawful.
Riff, what if mom had a belief that dad was letting child smoke marijuana at the house and then decide to set up that recording device?
Well, you're in that situation. I would, under your and I think my very forgiving standard of BRC, it's probably okay, because mom is going to say, well, I wasn't sure, but I might have needed a restraining order because I thought dad was abusing our kid by letting him smoke pot. So, yeah. I mean, one of the things, can I just say this? When you look at the cases, the very few cases that are out there, one is struck, in my opinion, by how finely the Court of Appeal parses the facts. There's so many facts that go into the decision as to why the Court of Appeal flopped this way or that way, that they almost have no precedential value. And it's really going to be a fact-specific inquiry, both for your trial court and in the Court of Appeal.
I want to add one more scenario to this. I was looking at the questions, but I think it's a natural question with this. We've all seen cases where at exchanges, the cameras come out and they're in each other's face. So there's nothing confidential. There's nothing surreptitious. There's nothing that people do not have knowledge of it happening. But what if, rather than letting each other know that there's recordings, they each have reason to believe that the other person is going to engage in abusive behavior. So they each have, without the other one knowing, their camera on or the recording device on in their pocket. And then you have a hearing where you've got dueling recordings, each one of them trying to establish in a mutual restraining order application case that the other person was the primary abuser. They're clearly both anticipating getting a restraining order. They're clearly both believing that the other person is the primary abuser or has been. Do you think you just have a situation where you're just going to have two sets of recordings to listen to and then make the determination again on credibility? Riff, I'm pretty sure you have not seen this. You've seen something close.
Well, I think the answer to your question is yes. Under the scenario you just laid out, I think both sides' recordings come in under, BRC and 633.6B.
Michael?
I agree with Judge Ripp, and I think it's actually, this goes into something that we've discussed in the past, which is I think it then brings in a lot of the context and a lot of it will be very interesting if a party edits or only provides certain parts of the video or the recording, and the other party then says, but wait, I was also recording, and here's the same recording, and here's the entire exchange, not just a snippet or the 30-second or 15-second video that that the other side brought in. Here's the entire 5 minutes of the exchange, and look, yes, I was yelling on this 30-second video, but look why I was yelling, and look what happened and what this person did beforehand. And I think that one brings context. Two, I would assume it would bring in a lot of credibility issues if one party says, listen to this recording, he or she's yelling at me, and the other party goes, listen to the whole recording, understand why I was yelling. I was just called these terrible words. He or she just threw something at me, and that's what caused me to yell. I think that, I think it would be a very interesting trial to sit through when that happens.
I think this is touching upon the next hypothetical, page 7. I think this is yours, Michael.
So in this hypothetical, we have a 5-year relationship. The parties were not married. Throughout the relationship, the parties had various arguments, money, over children, etc. Party 1, who's the moneyed party, ends up removing party 2 from the credit cards and questions party 2 about his or her fidelity. Party 2 then starts arguing with party 1. And when party 1 starts to argue back, party 2 starts recording. Party 1's unaware of the recording. Party 2 then files a domestic violence restraining order 5 months later and wants to seek to admit the tapes. Are the tapes admissible? And what about the context? Either one of the judges may feel free to jump in.
Riff.
Well,
I've had this one, so I want to hear you.
5 months later, huh?
I couldn't go 3 because that would have been too easy for you under BRC.
Well, I mean, not enough information to tell, I suppose. So what does P2 say in response to this question from the court? When you made the recording 5 months ago, what was your intention with respect to seeking a restraining order?
I knew I was going to need protection sometime.
Yeah. Well, I mean, if BRC is as forgiving as Michael suggests, and I am kind of coming along to agree with, then it comes in. And I mean, it's almost as soon as anybody says, someday I thought I might need it for my I recorded it because someday I thought I would need it. If that's the rule, then the answer to how far back you can record is however far back you thought maybe someday you might need it.
But there's a final component to this hypothetical, which does the judge bring up context? In this scenario, I did because if you look at bullet point 4, P2 doesn't turn the phone recording on until P1 starts to argue back. And don't you think, as a trier of fact, somebody needs to raise the context? And if not, you can ask the question?
Well, sure. I mean, so tell us, what would you ask in order to obtain more context?
I'll tell you what I did ask.
Okay.
To P2, you turned on this recording. Did P1 know that, in this case, he was getting recorded? No, I did it to protect myself. Was there a conversation before you turned it on? Yes. And did you record that? No. And what time of the day did this occur? In the middle of the night. And how did it start? I was upset with him and I went in the room. And then, what's astonishing to me is that I really believe that counsel needs to understand that when one side is raising the issue of recording, if they don't know, there's a rule of court that requires transcripts to be provided of any recorded document before it is introduced. And I don't see that anyone ever prepares these transcripts. They just march in with the tapes, but they are recorded. They are required under the rules of court to prepare transcripts. And I think that those need to be provided to the other side as well as to the court. And assuming that hasn't happened, if the court says questions about context and there is no other tape, then as far as I am concerned, there is a missing link because I have no idea what was said first.
But what if party 2 says, I didn't turn the record. I went in, I asked about this, but I didn't turn the recording on until I started to get yelled at. I didn't know he was going to yell at me or she was going to yell at me. I thought we were going to have a conversation. I was upset that my credit card got cut off and I was inquiring why. And then all of a sudden, the other side started yelling at me and screaming at me, and I turned the recording on. Well, I mean, I don't, to me, that might be a great answer because I don't think you need to record the entire conversation. I think that, at that point, if party two was trying to protect him or herself from abuse and started to feel that he or she was being abused after what could be argued was coercive control because they've argued over money and kids and the credit card got turned off.
Well, under the scenario I just said, P2 went into P1's room, which indicates that they were already having issues, and in the middle of the night started questioning about the credit card, and P1 got awakened and was yelling. And I don't know if I took a tally of everyone on this call, if they got awakened in the middle of the night and were questioned about having a credit card turned off. I don't know how many people would respond, "Oh, sweetheart, this is a good time to talk about." I do believe we'd have a lot of yelling. But at the end of the day, I think the point of this slide is context. And I think that whether it's done by a motion in limine or the court on its own bringing up the question, just because you're presented with a tape doesn't mean, as a trier of fact or as someone defending this, context isn't important. Context is clearly important. And we're going to get to some slides later about impeachment and credibility about these tapes. But please don't think that context isn't important.
And should aside from context too, I mean, Judge Riff was talking about timing. I think timing's important. I think this hypothetical changes and the potential of the admissibility changes if this was a record. Let's assume everything is the same, but the recording's from 3 years ago or 2 years ago. I don't know. Even if the person said, I was trying to protect myself or I was thinking about it 2 years ago, but I didn't do anything for 2 years or 3 years. And now all of a sudden I decided to file. I think that might be a much harder argument to argue in front of a judge than 5 months, 3 months, 6 months.
I think that's right, because no one has asked us to surrender our common sense. And, all things being equal, you've got this from 2 years ago, 8 months ago, or 5 years ago. If this is your best shot, it's not, in my mind, a good shot. But I think that this is where discretion comes in. I think it would be all of the circumstances that you'd have to look at.
So, I mean, as a practice pointer, guys, would you suggest maybe that the lawyer who's trying to get it out object or file, or I don't know, maybe file a motion to eliminate prior to try to exclude it versus waiting until we get to that time where the recording's trying to be admitted? Especially because there's so many what ifs.
I can't stress enough about the importance of motions in limine, because when people would come in my court and say, I've got 10 hours of tapes, my question is, really? I want to see them transcribed. And also there should be a motion in limine, because I don't know that I'm going to listen to 10 hours, maybe, but I really would urge people to utilize the statutes that are available in order to not only, if you think they should be and you want to create a record, and if you're trying to oppose them, at least understand what's being presented. Okay. Discovery question.
This assumes, a motion in limine assumes that the moving party knows what's coming. Under 6309, you may well not know until the morning of the hearing, here's the tape, Judge, I want to play it right now. And you're hearing it for the first time.
I mean, as a lawyer, that's where I jump up and down and ask for discovery under 6309 and a continuance of the hearing after it's played or before it's played, so I could file my motion in limine. And I mean, who knows what a judge would do at that point?
That's correct. A lot of discretion under 6309. That's our first conversation from last year.
Good plug.
I think it's you, Riff, isn't it?
Is this me?
I think so.
All right, well, this is a 6309 point. Let's just remember what 6309 is all about. 6309 permits discovery in DVRO matters, but it limits how it can be requested. It must be requested at the hearing and not before. With all of the caveats, presumably all 276 of you have already heard this about how even though 6309 exists, there's nothing stopping you from informally discussing with your learned opponent on the other side the possibility of exchanging some information in advance of your hearing. But basically, you don't get to do discovery until you ask for it at the hearing. So I would, should all recordings be requested? I would say that at the hearing, both sides should probably stand up and say, look, if the other side plans to use any recordings, I would like them produced now. And then the court can hold Evidence Code Section 402 hearings as necessary as to whether the circumstances under which they were obtained and whether they would be admitted under 633.6b and BRC. With respect to other discovery points, boy, we could just spend hours on this stuff. Generally speaking, in my opinion, is there a Fourth Amendment issue in civil discovery? Generally not. If you look at the academic literature, some very smart people out there have written very provocative articles about how a subpoena being the having the coercive force of the court behind it is government action. And yes, maybe there are some Fourth Amendment issues, but generally in civil discovery, including DVRO, expectation of privacy is covered under common law privacy privileges or issues and interests, I should say, rather than Fourth Amendment. Fifth Amendment, once again, we could have a whole seminar on this, but absolutely, one should be very careful about producing things that incriminate your client, and your client does have a Fifth Amendment privilege not to incriminate himself or herself in discovery. There are consequences, to be sure, of invoking the Fifth Amendment. One of them is not, however, that the other side gets to comment on it. You go in California, one can't say, well, they must be guilty of something, Your Honor. They invoke the Fifth Amendment. The Evidence Code specifically does not permit that here, even though it does in many other places. So that's as far as I'm going to go on this slide.
I want to just say one thing. California Rule of Court 2.1040 requires electronic recordings presented in evidence to be transcribed. And so I just think that that's a practice tip. Go ahead, Riff.
All right, well, this is such a great hypothetical. So you've got a wrongfully recorded communication, but we're just going to take that as a given. It's unlawful that it was recorded. And now the person who spoke in the unlawful recording is on the stand, and the question is put, well, it could be a variety of questions. And the person says, well, I don't remember. I have no recollection. Question, can you use the illegally recorded statement to refresh recollection? Those of you who are students of evidence remember the brilliant judge from New York, Judge Younger, saying you can refresh with anything. Here's the banana peel. Look at this banana peel. Does this refresh your recollection? Oh, yes, it does. I remember it was June 4th, 1982. So can you refresh? Question number one. Question number two, what if the witness says, well, I've looked at it, but it doesn't refresh my recollection. Can you admit it as past recollection recorded, assuming you lay the foundation? That's question number 2. Question number 3, what if the witness testifies exactly contrary to what's on the statement? So the statement is something like, and then I drove through the red light. You know, that's the illegally recorded statement. Then I drove through the red light, and that's what's on the tape. Now the witness is on the stand, and the question is, well, did you drive through the red light? And the witness says, no, absolutely not. Can you impeach with that illegally recorded statement? Well, the good news is, at least in my opinion, the answer to all 3 of those questions is yes, yes, and yes. And the case is Frio, F-R-I-O, versus Superior Court, a fascinating case, 203 Calap 3rd, 1480. And the case is People versus Crow, C-R-O-W, 28 Calap 4th, 440. And just commenting on the impeachment point, there's a very nice little parallel to the criminal law. If those of you who went to law school remember the Miranda case, well, you can't use a statement that was coercively obtained in violation of Miranda except to impeach. And the reason is that in this struggle of things that are really important to the court system, the truth-finding function of the court system is at the top of the heap. So liars will not be protected by Miranda or apparently 632 of the Penal Code. So I say it appears to be you can refresh, you can impeach, and you can introduce evidence as past recollection. Well, I'm not so sure about past recollection recorded. The Frio case discusses it, but I think it's dicta. That's what I have to say about that.
All right. And number 10, this is real quick, children's testimony in domestic violence cases. This recent case of Cardona versus Soto is important. The parents were in a hearing for a restraining order, and mom wanted a restraining order against dad, and it indicated that while dad was intoxicated, he beat his wife and mom in the daughter's presence. The daughter made an audio recording, and then after the daughter was contacted a relative for help, dad slapped her face. Dad was arrested, and the wife was taken to an emergency room. And mom requested a restraining order and alleged other incidents where dad had abused the child. At the hearing, the court spoke to the daughter alone in chambers and was so appalled about what the court heard. The court issued a 1-year restraining order protecting the daughter and the mom, and also granted mom sole legal and physical custody and denied dad visitation. This matter was reversed because the court violated dad's due process rights by basing the ruling on the interview with the daughter, and dad did not have an opportunity to question or respond to what was said in chambers. What's important about this hearing, this case, is the fact that a person has a right to cross-examine and to respond to allegations. So when a court speaks to a child in chambers and doesn't allow the party or parties to understand what happened, a restraining order cannot be issued without that right of confrontation. Michael?
Right. I mean, I think it's a little similar to how we have different evidence in domestic violence cases. I think this is one of those issues as an attorney. If you want the evidence in, and judges can interview children in chambers, you need to ask or remind the judge politely to please have a court reporter present, to please ensure that something is done to ensure that the evidence obtained will be able to be used so that you can actually present your case efficiently and properly.
All right. And finally, the takeaways. I just want to indicate to everybody, first of all, thank you for attending. I know we're rushing at the end, Just remember that 633.6 allows victims to record, but it's a limited exception to Penal Code Section 632. And because this evidence may be an exception, it doesn't forego your abilities to object, to preserve the record, and to use some of this evidence, if appropriate, to impeach or to refresh recollection. I know we have some potential questions. I don't know if anybody wants to stay over and answer, but thank you.
Yes, thank you so much. This was a lovely discussion. Maybe let's have time for just one question and you guys can, share your final thoughts. One question I did have here is there an exception of privacy on the doorstep of or on the private property of another, regardless of whether the camera is visible or known? Is it ever unlawful to record on your own property?
Riff?
It's interesting. If you go on the internet and look at that question, who's providing a lot of answers to that? Companies that install cameras on public property, because that question comes to them all the time. So, generally speaking, in wide open places, there is not a reasonable expectation of privacy. For images, that images are very different from words and audio recordings. But what can be seen from the street is not private, as opposed to peering through a hole into a fitting room at Nordstrom's, which is private. So I think generally speaking, things that are happening in the great out of doors are not private. It's going to be fact specific. Is there a cupola, or is it how open is it? And what these camera companies are saying is a good idea is post something that says, hey, by the way, you're being recorded. And when sometimes you're walking your dog down the street, you'll hear some robotic voice saying you are being recorded. If you're walking by, you're being recorded. So you can no longer have a reasonable expectation of privacy.
Thank you. Thank you, Riff, and thank you, Michael, for being a part of our ongoing travail through restraining order statutes and the cases that so interpret them. Thank you, Anna.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.